Great. Thank you for that introduction. Great to be here. Great to see Chosen Power here, who had a chance to spend time with you last night. And thank you to the organizers of this conference for this very, very kind invitation to join you. I want to, I think as others have mentioned, my contribution today is to focus on how do we begin to put this into practice, and how do we build a strategy that can move forward. Tina laid out a very comprehensive picture of the kind of legal framework and rights that need to be realized in people's lives and in our legal framework. And we heard about the example from Sharon in Israel about changing, the importance of changing actual practice in psychiatric hospitals and other facilities, and from Oliver using strategic litigation as one method. And I want to share some examples of strategies that have tried to put all of those pieces together to get local to national scale reform. How do we bring about the substantive changes at all levels of society that are going to enable people to have choice and control and power in their lives when it's been taken away from them in such harmful, traumatizing ways that leave them without equality, basic respect, and dignity in their lives and in their status in community. So I think we all sense how important this is to do. We all have in our own lives or in the lives of our friends and people we advocate for examples of how people's right to equality in the exercise of legal capacity, how their right to make choices in their lives have been taken away. So how do we build a strategy to change this reality? So I want to, and I'm going to, we're a bit shy in time, so I want to move through a few. I'm going to actually go through this. Well, actually, let me keep this one on. This is basically what we're trying to do, right? We all want to make choices in our lives about, how much room do I have for this? Here we are in the center, any one of us in the center of our lives, trying to make decisions about what we're going to do, things we like to do, decisions about how we're going to use our money, whether we're going to have a bank account, about giving consent to healthcare treatment and our dental care, where we're going to work, where we're going to live. When we talk about the right to equality in legal capacity, we're talking about something that's pretty basic and fundamental to our lives. And if we think about this circle as the community, legal capacity is really about what is the way we're going to make, how are we going to make our way into the community? Are we going to make our way into the community in ways according to our own choices? Or are we going to be placed in the community in ways that don't give us any power over our own lives? So it's really, that's what we're trying to do. It's right now, so many people with intellectual disabilities, psychosocial disabilities, are denied the right to make choices, all those choices in their lives. So it's quite basic what we're trying to accomplish. The questions I want to focus on, before we get into the strategies, I think we need to think about what is the theory of legal capacity that we're operating with? What do we mean by support to exercise legal capacity? And we've, I think as Tina and Sharon and Oliver have pointed to, the convention and the general comment give us some guidelines. But I think there's some gaps in what we've been given so far. And I think we need to build a fuller kind of theory of legal capacity if we're going to include people with a range of disabilities. My experience has been primarily with people with intellectual disabilities and their families, and my work in this area has been really driven from that experience and from the aspirations. I've had great opportunities to be able to work with people with psychosocial disabilities and their organizations, people with cognitive disabilities, dementia, and Alzheimer's, and I've learned immensely from those experiences. But my experience is primarily with people with intellectual disabilities. There's three main ideas in the general comment that I think we can use to build this theory. One, this idea of supports for legal capacity. And the idea that some people may need minimal supports, some people may need plain language, or an advocate to go with them to the bank so that they can make their decision. They can open a bank account or take their money out. Some people may need more maximal supports, which is what maximum supports, which the UN committee spoke about. And in that case, and we'll talk more about that, people need around them a network of people to help them have power over their lives. So this idea of a continuum of supports is a really important notion that shows up in the general comment. Supported decision-making, people often talk about, well, we're just trying to get supported decision-making in place. And they make supports for decision-making and supported decision-making one and the same thing. I think it's really important to distinguish them. Supports for decision-making is what's recognized in Article 12.3, that some people may require supports to exercise legal capacity on an equal basis with others. Supported decision-making is referenced in the general comment. It's a particular type of support. It's a type of support that involves having around you people who can help interpret what your will and preferences are and put them into actual legal decisions and arrangements. It's a type of support that's primarily about interpretive support. And it was developed from the experience of people with profound intellectual disabilities and their families and advocates. People who, when they go to the bank or the doctor, they may not understand what the financial decision is about or what the medical intervention is about. And no amount of support is ever going to enable them to understand what this particular treatment is or and whether they should choose it on their own or not. But they do know something. They know that they're in pain, and they don't like pain. And so if they had around them supporters that could help the doctor understand where their pain is and that they want to be out of their pain and help interpret for the physician what needs to happen, then that person is still guiding that decision. That person still has choice and control. They may not understand all the medical decisions, but they know what they want. Just like in my experience, being able to be with people with profound intellectual disabilities, they know who they like to be with, and they know who they don't like to be with. And their friends and family who know them well can interpret that. And their friends and family should help the service providers and community respect those decisions to make sure that if I don't want to be around that person and I communicate and gesture in ways that my friends understand, we should make darn sure that I don't have to be around those people. Now, the service provider, the community may not be able to communicate with me because they don't understand my form of communication, but I should still be able to have power over my own life. So when we talk about supported decision-making, what it's about is giving status to those people in my life who can interpret what's important to me and help put it into legal agreements. So if I don't like where I'm living, and I want to move somewhere else with a friend or move in with a friend who's a roommate, I may not understand what it means to sign a lease. But so what? What's important is that I want to be with my friend, and my supporters understand that we want to live together, and so that's actually the most important decision. I don't like where I'm living. I don't like those people that are around me. I like this person who's my friend. And then my supporters, their job is to help put into place the legal agreements and the rental agreements they're the ones that are doing all that understanding and appreciation that we associate with contracts, right? I'm never going to be able to do that, and that's okay. It doesn't matter. What my legal capacity is not about my capacity to understand the details of a legal agreement. Just like when you're online and you go to purchase something, you don't read that long list of things before you push I accept and you get your book on Kindle or something. You push one button, right? So because you want that book, or you want that you want those new pair of shoes or whatever you're getting online. So when we think about, I wanted to spend a bit of time on that. That's what supported decision making is about. It's for people who are not going to be able to understand and appreciate in ways that allow us to enter contracts all on our own. It is the support, the interpretive support by others who are committed to me, who know me personally, and on the basis, and whom I trust, personal knowledge, and commitment, and enable me to translate what's important to me, what matters to me, into all those legal agreements and arrangements that are going to give me power over my own life. Okay, so that's I wanted to spend some time on that core idea. I think one of the challenges that we've got in moving the equal right to legal capacity into a legal framework that's fully inclusive of people with more significant intellectual and cognitive and psychosocial disabilities is that we're stuck with some theories of legal capacity that the UN committee has rightly said are discriminatory, when these are the basis of our legal framework. So the status approach, in many laws, in the mental health laws in Hong Kong and in Canada and the US and Europe, basically, as Tina pointed out, you're given a status of mental disorder, and on that basis, you can be involuntarily treated or committed in some way. That's the status approach. Once you're given that status, you basically lose control over your life. There was some attempt to kind of correct that by saying, well, it's really only if you are causing harm to yourself or others, then we'll restrict those people. But that's similarly discriminatory, because guess what? It falls more on to people who have, it's combined with the status approach. You have a mental disorder, you're likely to cause harm to yourself or others, and so you're treated without your consent or against your will. So there was an attempt to say, well, no, okay, right. There's a problem with the status and the outcome approach. Let's focus on, you have the ability to understand and appreciate the consequences of this decision. And so the cognitive approach was used as the basis for legal capacity, but it's discriminatory, right? Because people with intellectual disabilities or significant cognitive disabilities don't meet that test. So what the committee said is, you know what, all of those are discriminatory. And people should have access to the support they need to exercise legal capacity. And you go, yeah, I agree, that makes sense. But what does that mean? What does it mean? What does maximal support actually mean? How do we turn that into legal capacity? We're still lacking a theory of legal capacity. And that's, I think, what we have to build and what we're collectively building through the work that we do. And this is sort of an approach that I'm working on with some colleagues who are lawyers. We refer to as a new formula for legal capacity, which we call decision-making capability. Okay? So the idea with decision-making capability is that we recognize that we all have unique abilities. The ground of legal capacity, the foundation, isn't that I can, in my own head, understand and appreciate, the nature and consequences of this decision and sign this contract. The ground of my ability is, as is said in Article 12.4, my will and preferences. The things that matter to me. My preferences are those things, my values, what's important to me, the things I care about. And those things are in our hearts, right? They're in our souls. They're in our very being. The things that matter to us don't come from intellectual work. They just come from who we are. They come from our experiences that we've had. They come from our traditions, our religious traditions, And maybe they come from rejecting our religious traditions, but they're uniquely ours. So the core ability is the ability to have things that matter to us. And that's, everybody has things that matter to them, right? And my will is my striving towards that. So the ground of legal capacity is my ability, plus the support that I need to translate that will into an actual decision. And as I said before, maybe I'm going to the bank and I just need an advocate because I feel shy and I feel uncomfortable when I talk to people at the bank. But maybe I actually don't understand what a bank is or what a contract is, and so the support I need is more supported decision making. I need people around me to interpret my will for the doctor or the financial institution. We need accommodation so that the bank or the physician accommodates my unique way of making decisions, and we need a legal status that recognizes that. This takes us to I think, and not everybody would agree with me on this, and I accept that when we think about a legal framework, we need to recognize both independent decision-making capability. That is, I still want to, right now at this point in my life, if I go to the doctor, I want to be able to make the choice about whether I'm going into that doctor's office on my own, or I'm going to bring one of my sons or my spouse. But the point is, the doctor has to get informed consent from me, right? The doctor has to have a sense that I understand and appreciate this decision. Because if the doctor doesn't get that sense, and they proceed and do the surgery on my leg, that's battery. Right? They haven't got informed consent from me unless I can demonstrate to that physician that I understand what's going on. I've chosen this treatment. But there are people who are never going to be able to understand that treatment, right? So our solution has been to put them under guardianship because we want to protect them. This is where we need another component in our legal framework, which I refer to as interdependent decision-making capability, which really recognizes supported decision-making, right? So in this case, I'm making the decision with those people who I choose on this basis of a personal relationship of trust and personal knowledge to translate what matters to me, getting rid of my pain, deciding to move in with my friend. They translate that into an actual decision. So in this case, interdependently, the physician is still confident that there's understanding and appreciation about whether we adopt this treatment or not. It's just that the understanding and appreciation isn't in my head, it's in my friends' heads. And it's in those people who have committed to act in a way based on my will and preferences. So there's still understanding and appreciation going on. It's just that that's in the heads of my supporters, whose job and legal obligation is to translate my will and preferences into a legal agreement. It's very much like we've got, and you have in this jurisdiction and other jurisdictions, appointments of powers of attorney, right? We appoint a power of attorney, an agent, to act for us in healthcare decisions for an advance directive, or in financial decisions, or in personal care decisions. The legal obligation of that agent is to make decisions that, to the best of their interpretation, accord with my will and preferences as the principal. I've appointed that person. The problem for people with more profound intellectual, cognitive, or psychosocial disabilities is that they're not seen as capable of making that appointment, right? Because it's a contract. So they're like excluded from being able to have a representative or a supporter in their life that's legally obligated to act for them in ways that are based on their will and preferences. So when we think about law reform, we've got to provide a way for people to get supporters legally recognized in this, for interdependent decision-making capability, who can act for them. Because power of attorney, the law, whatever that legal framework is, doesn't recognize people who can't independently make this appointment. That's, I think, one of our biggest legal challenges when we think about creating a framework, a legal framework for supported decision making. So with those kind of, I'm going to move through this because I want to get to this. Basically, that points to a legal framework would then recognize 3 different ways that I am going to make my way to the community, right? To make my healthcare decisions, financial decisions, personal decisions about where I'm going to live or work. I make them independently. I demonstrate to the physician or the bank that, yeah, I can enter this contract on my own. I understand and appreciate what's going on. Or, representative or a power of attorney, I appoint a power of attorney. They're doing the wheels in their own head about what I want to do. What we're missing is a legal recognition of supported decision making, of the appointment of supporters who assist me in and together with me bring understanding and appreciation to a legal contract. That's what we're missing, this 3rd way in the law. We've got this independently, we've got powers of attorney, and we've got guardianship, which we need to abolish. We can abolish it if we create this 3rd way that recognizes some people are going to use supports, some of the time or all of the time, to make decisions interdependently. So how do we make this happen? How do we give recognition to this theory of legal capacity? I think we need to think about change taking place at 4 levels. In our daily practice, in how families operate and support their family member, in the practice of a person going to a physician with their supporters to make a decision. So we need to change practice. We need to change at the community level how the local bank operates, how the policy of the healthcare facility or the institution. Sharon shared that amazing story about how they began to change the kind of policy and programs at the community level of this psychiatric facility by bringing data about how restraints were being used that violated people's basic rights to liberty and security of the person. So we can change at that level. We need to change the policy framework, the basic rules of how financial institutions work and our healthcare system work. And we need to change the legal framework so that, as I said in my earlier slide, we get legal recognition of supported decision making, of the appointment of supporters who can assist me to make decisions. So I've had the opportunity to be involved in various projects in different parts of the world, in Canada, in the US, in Bulgaria, in Zambia, Colombia, Peru, to learn from and learn with actors on the ground who are trying to bring about change. And so one of the things that I think has become clear from that experience is that you need to be able to work at all of these levels. I want to use the example that Oliver used with the case with Rusi Stanov. So Oliver was then executive director at Validity, what was then called a Mental Disability Advocacy Center, and they took this case and they won the case in the Court of Human Rights, European Court of Human Rights, 2012. About the same time, I started working with NGOs in Bulgaria on the ground to figure out what could we do with this case, like how, because it came down. Bulgaria was found to be in violation. But there was nothing was happening. There was no momentum. So what the first step was to bring together advocacy and self-advocacy organizations of people with intellectual disabilities and people with psychosocial disabilities to talk about how could we begin to change the practice on the ground, because they weren't even really sure what the legal framework should look like, but they knew they could change practice. So they started pilot projects. And basically, a pilot project is simply, in the examples I've been involved in, 8 to 10 people with intellectual disabilities, 8 to 10 people with psychosocial disabilities, who are looking to get supports established in their lives. And And you have a community organization or agency that supports those individuals in ways that make sense to them and in ways that they request. And the job is to provide that support and track what's happening, evaluate what's happening, and then use some of those lessons to begin conversations with policymakers, to begin conversations with hospitals, to begin conversations with financial institutions and policymakers. So it's a long story in Bulgaria, but the pilot project, one thing I want to make that's important, I think, to recognize is that this idea of supported decision making, and the reason I call it as one type of support is that it's very unique. Having a network of people around a person to help them plan for their lives, and they meet regularly, and they're a kind of a bridge to the community for that person. Not everybody wants that. Not everybody needs that. And it was very clear from the two different experiences in Bulgaria for people with psychosocial disabilities and people with intellectual disabilities. People with intellectual disabilities, that network of supporters was built around each of the individuals. People committed family members, and they invited, some people were very isolated, and they invited community members in, and they developed a network and a plan for that person's life, about what that person wanted, and then help them activate that plan into reality. And that's all supported decision making is, right? It's not rocket science. It's like, I have a plan for my life, someone helps me figure that out, and then they help me put it into practice. For people with psychosocial disabilities in this pilot, people didn't want a network around them all the time. They wanted some assistance because the networks they had around them, often their families, had been a huge part of the problem in many people's lives. So they rejected that whole approach. And what they wanted was an advocate with them that would stay with them or be available to them as they wanted. And we know from the examples in Sweden of the personal ombud system that this has been a very effective approach. The pilot project, it's really interesting. So this community group in Bulgaria, they transformed themselves and totally committed to this idea of the equal right to legal capacity for people with psychosocial disabilities, and made sure that there was always available 24/7 a person, an advocate who would be with that person, whether they were on the street, whether they were, the police were showing up, they would be available to that person. And it was actually the social workers with this agency who had to basically change their practice. The people with intellectual disabilities were no longer clients psychosocial disabilities were no longer clients of the service. They were citizens. And the social workers had to become their supporters and their advocates. And since that pilot project began, it's now 4 years in the making, people were routinely, there's 35 people now in that pilot project, routinely involuntarily committed and treated. And since they worked this process of support out, not one has been involuntarily treated or committed into a psychiatric facility. Sometimes people have gone voluntarily. The group has looked to create community-based support for them, but their commitment has been to stick by that person and learn to interpret what that person wanted. The pilot project with people with intellectual disabilities has grown from that original 8 to 10 people. It's now in 30 communities across the country. And they've developed a training for facilitators of supported decision-making networks, and continue to grow that. As Oliver said, they also developed proposals for law reform, which are incredibly progressive, but because of political realities in Bulgaria, it hasn't been able to be implemented. Strategic litigation has fulfilled a very interesting place in that strategy. As people developed new forms of support around them, they had the legal team go with them to the court to have guardianship vacated. Because whether it's here or in Bulgaria or in the US, guardianship is still seen as a last resort. So if you can demonstrate to the court that you have an alternative support arrangement, you can begin to get guardianship vacated. They lost a couple of the first few cases, but they've started to win the cases. And because they go to court and say, this person has a network, we have a demonstrated practice, there is an agreement between the person and the supporters, and judges have started to vacate guardianship. And so the other part of the process and the strategy is training of the judges. And now some of the judges themselves are involved in training other judges about what it means to recognize supports to exercise legal capacity. I think I'll leave it there. I guess my kind of closing message is, it's nobody else. Like, we can call for an equal right to legal capacity, eradicate guardianship, change the mental health laws, and the state has a responsibility to do that. Absolutely they do. And to put supports in place for people in communities. The problem is they don't actually know how to do it. They don't have a theory. They're stuck in the old theories of legal capacity. They don't have an alternative theory. They don't know how to do this. Only you know how to do this. If this is going to happen, it's only because you decide collectively to work together to make this happen. There are good people. They just can't imagine how you could change the law, how you could do it differently. So I just want to really encourage that you create some partnerships just to start this work. Start with pilot projects. If there's an obvious case for litigation, as Oliver mentioned, get into court and drive that through. The most important thing, though, I think, is that you create a space where you're working together. Like the people that you've gathered here today. You've got lawyers, you've got self-advocates, you've got community-based organizations. I know there's service providers in the room, representatives of service providers in the room. Like, create a group that takes this on. It's going to be a commitment, right, of 3 to 4 to 5 years. But start changing practice. Start working then with the financial institutions and the hospitals to change their policies. Find that legal case that could make a difference. And also, start crafting, based on your experience, the changes in the legal regime that you want to see happen. And when the time is right, you will have built a constituency, right, of advocates and self-advocates. And maybe you'll actually find a psychiatrist in the hospital who gets a new theory, the alternative approach, or the head of the Chamber of Commerce, or a senior law firm who's done pro bono work with you. You're going to need those when you sit down at the Legislative Assembly, right? And you bring forward this law, and legislators are going to go, "What are you talking about?" You're going to have people, then you've got a constituency who can speak up, who can share the experience, who can share their passion and their belief in why this has to change and how it looks when it changes. Because you will have had examples from a pilot project and from the accounts of the financial institution and the healthcare system. So I guess I'm finished now. I keep getting these signs, I realize. I'll leave it there. Good luck with it.